Hello everyone, welcome back to our channel, Immigration YT We hope you're doing great. In this video, we will discuss can the government take away your U.S. citizenship, understanding denaturalization and renunciation. If you are interested in this, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell and upcoming video. U.S. citizenship is one of the most powerful legal statuses in the world, granting individuals the right to live, work, vote, and seek protection under the law. For natural-born citizens, those born on U.S. soil, this status is safeguarded by the 14th Amendment and is essentially permanent. But for naturalized citizens, those who obtain citizenship after immigrating, there are rare yet real circumstances under which citizenship can be revoked. Understanding these legal grounds is essential for anyone who has earned U.S. citizenship through the naturalization process. What is U.S. citizenship and why does it matter? Citizenship in the United States is not just a legal title. It's a gateway to fundamental rights and privileges. It includes the right to vote, hold a U.S. passport, seek federal employment, sponsor family members for immigration, and access full protection under the Constitution. For natural-born citizens, these rights are granted automatically. For naturalized citizens, they are earned through a thorough process that includes residency requirements, background checks, interviews, and civics and language tests. However, while naturalization is generally considered final, it is not always irrevocable. Under certain legal circumstances, the U.S. government can denaturalize a person, effectively stripping them of their citizenship. Denaturalization, when citizenship is revoked. The primary method by which the government can revoke someone's U.S. citizenship is through a legal process known as denaturalization. Importantly, denaturalization applies only to naturalized citizens. Natural-born U.S. citizens cannot have their citizenship taken away involuntarily, thanks to constitutional protections under the 14th Amendment. The U.S. Citizenship and Immigration Services outlines several legal grounds for denaturalization. Illegal procurement. If you did not actually qualify for naturalization when you applied, perhaps because you didn't fulfill the residency requirement, or you lacked good moral character, your citizenship can be revoked. This applies even if your application was approved due to an oversight or error, fraud or willful misrepresentation. If you intentionally lied or concealed critical information during the naturalization process, such as a criminal history, previous deportation, or use of a false identity, you can be subject to denaturalization. In Maslin-Jack v. United States in 2017, the Supreme Court ruled that only material misrepresentations, those that would have influenced the decision to grant citizenship, can justify revocation. Affiliation with subversive groups. If within 5 years of naturalization, a person is found to have been affiliated with a group that is hostile to U.S. interests, such as terrorist organizations or groups advocating for the violent overthrow of the government, their citizenship may be revoked. Dishonorable military discharge. For individuals who became citizens through military service, a dishonorable discharge before completing 5 years of honorable service may result in denaturalization. Though these cases are rare, the process is serious. It is conducted through federal court proceedings and requires the government to provide clear, convincing evidence. According to the Immigrant Legal Resource Center, there were an average of just 11 denaturalization cases per year between 1990 and 2017. However, between 2017 and 2020, there was a noticeable uptick in such cases. Renunciation, voluntarily giving up citizenship. Not all loss of citizenship is involuntary. Some individuals choose to give up their U.S. citizenship through a process called renunciation. This usually occurs at a U.S. embassy or consulate abroad and must be done with clear intent. Under the Immigration and Nationality Act, several actions may be considered expatriating acts, including acquiring citizenship in another country with intent to relinquish U.S. citizenship, taking an oath of allegiance to a foreign government, serving in the armed forces of a country hostile to the U.S., formally renouncing citizenship at a U.S. embassy or during wartime within the U.S. with Justice Department approval, committing treason or attempting to overthrow the U.S. government, in extremely rare cases. In 2023, around 5,900 individuals renounced their U.S. citizenship, according to State Department data. Many cited dual citizenship complications or U.S. tax laws as their motivation. Recent trends and controversies. The issue of denaturalization became more politically charged during the Trump administration. In 2020, the Department of Justice launched a denaturalization section focused on targeting individuals who fraudulently obtained citizenship, including war criminals, human rights violators, and national security threats. Civil liberties organizations, including the ACLU, expressed concerns that such efforts could be misused or overreach into less serious cases, potentially creating fear within immigrant communities. Government data reveals that nearly 40% of all denaturalization cases since 2008 were filed after 2017, marking a noticeable increase in enforcement activity. How to protect your citizenship. For naturalized citizens, the best protection against denaturalization is simple: honesty and compliance. Here are steps to ensure your status remains secure. Be truthful on all immigration applications and during interviews. Keep all documentation related to your naturalization process, including forms, approvals, and interview notes. Stay informed about your rights and any updates to immigration law. Avoid affiliations with extremist groups or actions that may be interpreted as hostile to U.S. interests. Final thoughts. Losing U.S. citizenship is extremely rare, but it is legally possible under specific conditions for naturalized citizens. Whether through fraudulent acquisition or voluntary renunciation, the law provides a clear pathway for revocation, but it also ensures that the process is rigorous and just. By understanding these rules and safeguarding your conduct, you can protect one of the most valuable assets a person can hold: American citizenship. That is all today in this video. What are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.